Can I sell a house in probate for less than 90% of the court's appraisal? There's a lot of misconceptions about this one. We're going to get into that right now. Welcome back to the channel featuring California's leading probate real estate team. I'm Brendan Mohr, realtor and certified probate and trust specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary as well as a registered and bonded legal document assistant specializing in probate work in California.
Now please like this video, subscribe right now. Want a no-cost probate service? Well, every day we help people save thousands of dollars and eliminate headaches with our one-of-a-kind probate administration service and real estate listing combo. If it's in California and real estate needs to be sold, you may qualify. So please reach out, even if you've started your probate with somebody else or on your own. Our info is on the channel in our About section. We love your calls, texts, emails, and comments. Now let's get into it. So can you sell a house in probate for less than 90% of the court's appraisal? And when we're talking about that, there's something in probate called the probate referee.
Yeah.
Maybe briefly touch on what the probate referee's job is.
Sure, absolutely. The probate referee is just a court-appointed appraiser, and basically his job is to give the court values of the assets of the estate as of the date of passing. And obviously a probate home is an estate asset and it needs to have its value established as of date of death. Again, that's what the probate referee does.
Yeah, now I would say that there's a big misconception when it comes to this rule, this 90% rule. And if you go online and you search, can I sell a house in probate for less than 90% of the court's appraisal or the probate referee's value, there's gonna be a lot of blogs, even from attorneys, real estate brokerages even, saying that you can't. And it can be quite confusing. And then you're gonna see other blogs say that you can.
Yeah.
So which one is right?
Yeah, a lot of misinformation out there, that's for sure. Well, the only time you have to sell a house, probate home, for at least 90% of the court appraised value is if you're in a limited authority and or a court confirmation situation where you have to take the purchase agreement to court and have them confirm the sale. If that's the case, then yes, the offer has to be within 90% of the court appraised value. Now that in itself can be tricky because the probate referee gives a court value, appraised value of the property as of date of death. But here's a little quagmire. If it's been more than a year since the person passed away and you're going through a court confirmation sale, you have to go back to the probate referee and get what's called a reappraisal for sale, which then gives a current value to the home the probate referee gives you. Hopefully that's within 90% that your offer is now within 90% of the reappraisal for sale value. And I know that can be confusing. So just try to remember that if the sale is going to occur less than a year from the time the person passed, then you use the original date of death appraisal. If you're going to sell the house more than a year, then you've got to do a reappraisal for sale to get current market value.
Now there's two types of authority in probate for a personal representative. That's
Sure.
essentially if you're the administrator or executor of the estate. It could be limited authority, mostly what Bill was just talking about there,
Right.
or full authority. And full authority is really what most personal representatives tend to have. So in that limited authority situation where any sale has to go to the court and the court approve it, then that's where that comes into play. But a probate referee, whether you have limited authority or full authority, has to do their job with that valuation. So sometimes people get that confused, like, oh, why is there a probate referee if that value doesn't matter for the sale of real estate in full authority?
Well, I can chime in on that a little bit. Regardless of if you're selling a home in probate or not, you always have to have date of death values for the overall probate. It's a requirement by the probate code and the court. So whether you're selling the house or not, you're going to have a probate referee do a date of death value on the house. It has to happen in probate. It has to.
Now that's great insight, because I get that question a lot as well. Now, when you do have full authority, no, you can sell the house for $1. But in full authority, if you're the only heir or beneficiary, then that's great. Then you're the only one, the only part of the estate, the only member of the estate who you're looking out for. But
Right.
a personal representative has to act in the best interest of the estate.
Yep.
So in most cases, there are more than one heir or beneficiary.
Yeah.
So if you end up selling for a house for $1, then probably the other heirs or beneficiaries are not going to like that.
Yeah, they'll probably object to that sale. And if for some reason they don't object and they agree to it, okay, but who knows if later on that's going to come back to bite the administrator for trying to push that through. And the court, if all the heirs are in agreement for that $1 sale, it will probably go through, but I would imagine that a probate judge would probably have some questions about that.
Maybe I should put the example a little bit higher than $1, because that's ridiculous.
Yeah.
But let's just say 80% of the probate referee's value, just for the sake of it.
Sure.
But so in limited authority, what happens is it goes to the court and the judge basically says whether or not that's an acceptable price. And by that law, that part of the probate code, most likely is going to look at it and say this has to be at least 90%. In full authority, you have to send a notice of proposed action to any of the heirs or beneficiaries showing how much this house is being sold for. And it's then up to them whether or not they're going to object.
Correct.
Now, what happens if they object?
Oh boy. Well, if you have a full authority situation as you're describing, and one or more of the heirs object by signing the objection line on the notice of proposed action and sending it back, then that pushes you into a situation that is very similar to a limited authority situation. You're going to have to go to a court confirmation hearing to try to get the court to approve the sale. So you're not totally out of luck. It's not as if you can't get the sale done when an heir objects, but you're going to have to go through court confirmation hearing. And it's very likely that the objecting heir or heirs will show up at that hearing, and the judge will want to know, well, what are your reasons for not wanting the sale to go through? And they better have good reasons, because if they don't, the judge will send it through and approve the sale anyway. Yeah.
And that would be more common based on a sale that is lower than the probate referee's valuation. Now, sometimes people think that the probate referee's valuation is too high. Sometimes it actually is.
Yeah, no, that's true. Very true.
Yeah.
Very true. And you actually can go back to the probate referee and more or less say, hey, I want you to take a second look at this because we think your appraisal's too high. And they will. The probate referee will take a look at it, and oftentimes they will adjust it. But another situation similar to that is you've got a court confirmation hearing, and you've got an offer that's not at 90%, but it's maybe 80% or 85%. You can always go back to that probate referee and say, hey, look, we've got this offer. Can you take another look and reappraise so that we can be within 90% of the sales price? A lot of probate referees are very cooperative, and if it's reasonable, they will adjust. They'll give you a new value that puts you within that 90% where you need to be. As long as you don't bring them a ridiculously low offer way under market value, and you got to be reasonable about it.
And I would say that is maybe one of the big reasons. A ridiculously low offer would be one of the reasons why an heir would object.
Correct.
But yeah, you can sell a house for less than 90% of the probate referee's value. Just as a personal representative, you want to watch out, make sure you have really good communication with the other heirs or beneficiaries, because you really don't want an objection, because you might have a good buyer at that time. And
yeah, you could very well lose that buyer
yes.
if you get an objection, and then you got to take all the time to go do a court confirmation. That buyer may not want to wait around for a lot of reasons.
It could take months at that point.
Yeah.
Now, you might be watching this video and saying, but this is a real thing that somebody recently called on our channel and said to me, they wanted to sell their house for essentially under 90% of that value and had a buyer lined up and everything. And all the heirs were apparently in agreement. And she said, well, my attorney says I can't sell it for less than 90%, but I have full authority. Just because an attorney's website says they do probate doesn't mean they specialize in it. And even if they have done some probate, doesn't mean they are all that great at the real estate side of it, because probate is far more than real estate.
Yeah.
There's a lot of great attorneys out there, but not everybody who says that they're a professional at something is a professional at something. We get that in real estate as well.
Yeah, I was just saying, and I don't mean to, as I think everybody knows out there, we're not attorneys and we're certainly not giving legal advice, but sometimes you will run into attorneys who, for whatever reason, are not real familiar with the probate process. But I will say this, I do want to make sure that we say this. If you have an attorney telling you that you have to sell it for at least 90% of the court appraised value, and you have full authority, my recommendation would be to seek out another probate attorney, pay him or her $100, $150 for a 45-minute consultation, and ask their opinion. Get a second opinion. Tell them your situation, see what their advice is. It may be the same as the attorney you're dealing with, and if it is, that's fine. It may not be the same, and then you may have cause to go back to your attorney and say, hey, look, consulted with another probate attorney, and they're saying this. Get a second opinion if it doesn't seem right to you.
So the long and short of it, right? You can sell a house in probate for under 90% of the court's appraisal, if you have full authority especially. But you do want to watch out. You want to make sure that you are doing everything you're doing in the best interest of the estate. So you want to have good communication with the other heirs or beneficiaries if you do that. Otherwise, you'll be facing objection. It can be viewed as that you're not acting in the best interest of the estate. So you want to get out in front of that. Anything else you'd like to add to this one?
I think we covered pretty much everything on it.
Yeah, and please watch some of our other videos on probate referees and why the probate referee's appraisal isn't necessarily a great valuation or a realistic valuation of the property. And yeah, we get into that in a lot of other videos, but I'd say what you really need to know is perhaps a better idea of the entire probate process. We have a great video, it's only 5 minutes long. It's called California Probate Real Estate Sales Explained in 5 minutes. It's exactly that long, maybe just a little bit less, and it's going to appear right over where I'm sitting right now.